Hi, I'm Jamie Markham. As you can see, we're trying something a little bit different today. This is our first video post on the blog. And since we're near the start of the new year, what I thought I'd do today is take a look ahead at some of the sentencing and corrections issues that I expect to come up in 2011. It's by no means a comprehensive list, it's just some things that I think are on the horizon and likely to be of interest to people who follow criminal law in North Carolina. The first thing I wanted to mention has to do with sex offenders and some changes that will need to be made to our laws this year to keep us in compliance with federal law. In 2006, Congress passed the Adam Walsh Act. Part of that was the Sex Offender Registration and Notification Act, or SORNA. Under SORNA, there is a baseline for how states need to structure their registration regimes to continue to receive certain federal funds. The original compliance date for SORNA was back in 2009. At that point, North Carolina, like basically every other state, was not in compliance with SORNA, but we got two one-year extensions from the United States Attorney General. The new compliance date is coming up. It's July 27th of 2011. So the General Assembly have to make some changes by then to keep us in compliance. As far as what changes need to be made, I think there are a few. We're going to have to make some changes to our minimum registration period. Right now it's as little as 10 years for some offenders. It'll need to be bumped up to at least 15 or at least 25 in some cases. We have to make some changes to the retroactivity coverage of our effective date provisions. They need to basically be fully retroactive. That's not for everybody, it's just for people who are still in contact with the criminal justice system or who come back into contact with the criminal justice system. But regardless of their offense date, if it's reportable now, if the crime is reportable now, they would have to register. I think we'll need to add at least one crime to the list of reportable offenses. I think we'll need to add statutory rape of a 13, 14, or 15-year-old by someone who's more than 4 but less than 6 years older than the victim. And I think we'll have to make some changes to our juvenile registration requirements. That's something that's been controversial in other states and I expect will possibly be controversial here. So big changes coming in the sex offender laws. The next thing I wanted to mention is also another legislative issue, and it's regarding Class 3 misdemeanors. Last year the General Assembly passed a bill setting out their intention that there be only 3 classes of misdemeanors: Class A1, Class 1, and Class 2. They asked the Sentencing Commission to look at all Class 3 misdemeanors and make a recommendation as to whether each one should bump up to be a Class 2 misdemeanor or go down to be an infraction. The committee did that. I think the intention was in part to achieve some cost savings by decriminalizing some things. So the committee did that, reviewed the hundreds of Class 3 misdemeanors, and what happened, I think, was that there were a substantial number of Class 3 misdemeanors that the committee felt, for a variety of reasons, needed to be crimes. They didn't want to make them infractions. But because of the way the legislative mandate was structured, to keep them crimes, they had to bump them up to a Class 2 misdemeanor. Because the average jail time for a Class 2 misdemeanor is about 3 times more than a Class 3 misdemeanor, the net effect of all the committee's recommendations actually wound up being a cost increase. So the committee made its recommendations. But among those recommendations was asking the General Assembly to perhaps reconsider the legislative mandate in a way that would allow them to keep a crime, a Class 3 misdemeanor, status quo, that it wouldn't eliminate Class 3 misdemeanors altogether, but they, some would go up, some would go down, some would stay put. So we'll see what happens with that. Shifting from the General Assembly to the courts, I don't think you've heard the last word on this group of life-sentenced inmates from the 1970s who committed their crimes at a time when the law said a sentence of life imprisonment would be considered a sentence of 80 years. You may remember that in a case called State v. Bowden, the Court of Appeals said that means those sentences are 80-year sentences for all purposes, not just for parole eligibility determination, for example. Then in Jones v. Keller, the state Supreme Court said that the inmates were not entitled to certain credits, sentence reduction credits, that would have made them eligible for release now. I I think you might see at least two things with those inmates. One is you may see some action in the federal courts if they seek habeas review there. The other is if you look carefully at the Jones versus Keller opinion, you can see that the controlling opinion there really only speaks about inmates who are convicted of first-degree murder. There are other inmates in this group who committed other crimes, still very serious crimes, but less serious than first-degree murder. And based on the way the Supreme Court set out its constitutional analysis in that case, I think the non-first-degree murder inmates may still have a case in state court. So we'll see what happens with that. The last thing I wanted to mention, something I think you might hear about this year, called justice reinvestment. I know some of you have heard a lot about it already. What it is a project run by a nonprofit group called the Council of State Governments, and their basic concept is to encourage states to take some of the money they ordinarily spend on prisons and instead, which of course are very expensive, and instead reinvest that money into the community in ways that reduce crime, especially targeted at repeat offenders, recidivists. There's a lot more to it than that, but North Carolina is one of about 15 states that are participating in the project, and the group's recommendations for North Carolina are due out very soon. I don't know exactly what the recommendations will say, but looking at some of the packages they've put together for other states, I wouldn't be surprised to see substantial recommendation for substantial changes to the sentencing grid, especially for low-level felonies, but also for misdemeanors. I wouldn't be surprised to see a proposal for increased use of post-release supervision, and I also wouldn't be surprised to see some recommendations about fundamental changes to the way we do probation supervision in the state. So I'm interested to see that report when it comes out. I probably will write about it on the blog. So those are some of the things that are on my mind for the coming year. Always welcome your feedback. Feel free to post a comment about the things I've talked about or some of the things you think I should have talked about. And let me know about this experiment with a new medium. I may do it again if I have a post that would benefit from the use of a visual aid or something like that. If nothing else, it'll help you put a face with a name. So thanks, and Happy New Year.